page 252 of the textbook, and this was an article that looked at patent trolls, exactly what they are, what they do, and some of the ramifications of them. I'd indicate that whenever you say the patent troll, or a patent troll, that is often the pejorative type term that is used. The more polite term, in case you're wondering, is a non-practicing entity or a patent assertion entity. So an NPE or PAE is more the politically type correct term. But regardless, patent trolls is very much what has occupied the rhetoric in Congress over the last 10 years. They've been trying to, quote, eliminate patent trolls or the effects of them. Now, what is interesting is that when you look at patent trolls, they would globally define patent trolls as entities that do not create technology but only license it. So let's take a classic example where you have an LLC that you start up in Texas, and that LLC, let's say that we call it, Patent Assertion Tower, and that's just the name of our company, Patent Assertion Tower, and we transfer patents to that company. That company never produces anything. Their only assets is the intellectual property. So it's these intangible assets that they are holding on, and they simply go out and they sell and they sue people. And it's that type of some may feel that they shouldn't be able to sue if they in fact are not if they are not creating products associated with what their patent is actually producing or protecting rather. But that being said, if we went back to one of our first lectures, looking at some of the social benefits of the whole patent system, one of the pros and cons of this approach was that we wanted to give people an incentive to invent. And one of the cons or drawbacks of that was, in order to give that incentive, we said, all right, one, you would get a limited monopoly for a time, and two, you do not even need to create the actual technology. A patent gives you the exclusive right to make, use, or sell the technology. So it doesn't even indicate that you have a right to create the technology, because the right to create may depend on other licenses themselves. So it gives you a right to make, use, or sell the technology. Okay, so the first question there is, can a university be considered a patent troll? And under the wide type generic definition that I just gave, the answer is yes. A university, generally speaking, does not create any products. They are simply a research type approach where they're coming up with new inventions, and then they go out and they protect those inventions, and in some instances they even assert them. And so because they are not creating actual products associated with their innovation, they also at times have been labeled as a patent troll. Now, what is the solution that likely will have the greatest impact on the community? And I will give you my personal opinion there, and that is simply that the greatest effect on the community itself will be when Congress clarifies how it is that patents can in fact be used. So in 2012, the AIA Act, the American Invents Act, that went into effect, limited some of the rights of patent owners. And there was subsequent litigation and subsequent direction from that time frame that continued to diminish some of the rights of patent owners. And not only that, but it increased the risk of patent owners. So if a patent owner were to bring a lawsuit, there may be potential levies, sanctions that actually may be targeted against the patent owner to pay for the other attorney's side. So fees of the attorneys of the other side. There is limitations on where it is that you actually can file a patent lawsuit nowadays. So before, some of the venue type considerations was a lot more liberal as to where it is that you can actually file. So venue considerations, fee shifting considerations, and some of the AIA Act provisions, namely the IPR type process, have all kind of contributed together to effectively changing the whole landscape of patent assertions. So one of the most effective solutions, from my point of view, would be for Congress to get involved for the purposes of actually creating rules and regulations that allow patent owners to still assert their rights. So I would note that there are currently, I think, in the range of about 4 different patent reform acts currently before Congress. Again, this is 2019. There are many in the community that are hopeful that one of these acts will actually proceed forward into law that hopefully should assist with granting more rights back to patent owners. So let's go back to our discussion of the Wright brothers. I finished by indicating that in the 1910 time frame, the Wright brothers began to incorporate some of the models and construction of Glenn Curtiss into their own aircraft. Now, what we see, and this provides a little bit of the basis for where it is that Glenn Curtiss came from and how it is that he contributed to the aircraft industry as well. So after 1906 timeframe, the Wright brothers then approached Thomas Selfridge, who is a member of the Aerial Experiment Association. And you can almost think of them as these genius minds that were coming together, and they love to kind of diddle and daddle with respect to aircraft and explore the possibility of potentially flying. So the AEA, that's the Aerial Experiment Association, constructed several aircraft, including the Red Wing and the White Wing. Glenn Curtiss, was actually a bicycle maker repair guy as well. Very similar to the Wright brothers as far as background, understanding of aerodynamics, things of that nature. So he got involved in the AEA, and he was one of the test pilots for the White Wing, and he ended up flying it for over 1,000 feet. Again, this was after 1903 when the Wright brothers originally did it. But you can see that where the Wright brothers began to stifle in their progress of the technology, the AEA came along and really started to build upon what it is the Wright brothers had come up with. Curtiss actually then got involved to actually design his own aircraft, which he called the June Bug, and he ended up flying that almost an entire mile, 5,360 feet. That won him a prize by Scientific American. He ended up winning another prize for flying 25 miles in a plane that he designed. So 25 miles, this was a record during the time frame. Obviously anything over 12 seconds was almost considered a record at that point. But 25 miles, very significant, early 1900s. Now all these planes supposedly used the same Wright patented method of this wing warping type mentality. At the end of the day, what did the Wright brothers do? They sued Glenn Curtiss, claiming patent infringement. And what ended up occurring is that Glenn Curtiss came back and said, okay, I recognize that you're suing me because my wings can be warped. That's not a problem. I'll just add little mini wings on the end, which he called ailerons. And those ailerons, in fact, you almost see that today in even some, in almost all modern aircraft, where you see the flaps on the wing go up and down. And that's in essence a more modern aileron. But it was Glenn Curtiss, he put these on the very ends of his aircraft, and you can see the arrows in my figure. And these ailerons would go up or down. So there wasn't any warping of the wing whatsoever. It was just simply a little tab that went up and went down, allowed him to control the airplane in a different manner. Now, Alexander Graham Bell, Glenn Curtiss, and the rest of the team developed, again, obviously, a more efficient use of these ailerons that Glenn Curtiss came up with. They were sometimes called also wing flaps. And they were trying to specifically get around this Wright patent. And what ended up occurring in 1910, there was a preliminary injunction that was ruled against Curtiss, which in essence prevented Curtiss from being able to use aircraft or being able to further innovate on this aircraft that they had developed. Now, what was interesting is that in 1913, a judge came down and also said, well, your ailerons also infringe the Wright brothers patent. In other words, you can't even go through that process. Now, what is really interesting is that Henry Ford's attorneys then started getting involved. Now, some backdrop there. Henry Ford had been in a similar type situation, namely, he had obviously done a lot of innovation with respect to the car industry. There were all these other emerging car manufacturers that started to infringe his patent. And he had to spend a lot of money trying to clear the deck as far as all this potential infringement that was going on. But what Henry Ford found was that they thought that Glenn Curtiss here was actually really improving the innovation. And not only that, but they felt that the ailerons would get around this concept of wing warping, therefore the Wright brothers patent should not apply. Henry Ford's attorneys at the end of the day actually did have some success, and they were able to get the verdict stayed while it was being appealed. Again, this was 1913. Now, Orville Wright indicated to everyone in the industry that there would be a 20% royalty rate on any aircraft that was manufactured. A 20% royalty on any, it doesn't matter what type of aircraft it was. Their position was that their patent covered any and all aircraft, and that there would be a 20% royalty on the sales of that. Now they indicated, and this kind of gives you an idea as to the interplay that was going on between the Wright brothers and Glenn Curtiss, but Orville Wright indicated that that condition of the 20% would apply to everyone except Glenn Curtiss. So they would not even they did not want Glenn Curtiss to even be an active player in the market. They were trying to literally force him out. Now what was interesting is that during this time frame, Curtiss, or the Smithsonian, sent to Curtiss the original Langley plane. So again, this is the 1900s. And the premise of that was, well, can the Langley plane fly? Because that was the whole basis that was kind of the foundation for the Wright brothers getting a patent. And the thought process here was simply, if the Langley plane actually can fly, then that may be a means to invalidate the patent that the Wright brothers ended up receiving. And so Curtiss at the end of the day succeeded. And some speculate that when Professor Langley actually had tested that aircraft 10 plus years earlier, it was just a combination of sad events. If the wind wasn't right and the conditions were right, that caused the plane to not fly that day. But Curtiss proved that the plane actually was capable of flight. And in fact, the Smithsonian thereafter indicated a placard at the event at the Smithsonian indicating the first man-carrying airplane in the history of the world capable of sustained free flight. And that kind of debunked what it is that the Wright brothers up to that time had held, namely that they were the first airplane in the history of the world that could sustain free flight. And so it overcame this notion that the Wright brothers actually were the first. Glenn Curtiss, however, the flip side of that is that he did agree, or at least admit, that he had to, quote, make a few modifications to the original plane. He contended that there were only minor modifications. He had to reduce some of the wing material that had kind of degraded over the last 10 years. So he had to rebuild part of the aircraft, and in rebuilding it, he made some minor adjustments and modifications. And that may be one of the reasons why it is that the plane was not used for purposes of invalidating the patent. It was used as a basis for the Smithsonian to indicate this was the first airplane capable of achieving sustained flight, but it did not necessarily change the state of the litigation. So 1914 is when there was a judge, Judge Hazel, that indicating, and this was very much kind of a pivotal moment in this whole process, indicated the wing warpings patent, the Wright brothers wing warping patent, covered any and all forms of controlled powered flight. Now that is huge. That is huge. So any and all forms of controlled powered flight. You think about that. If it can go up, it is covered by the Wright brothers. So prior I indicated that the Wright brothers were trying to get a 20% royalty, but now they even had a backing for it. And they could say, you know what, the judge has indicated any aircraft capable of powered flight has to come through us. And that is in essence what they were doing. And that gave the Wright brothers a complete monopoly on all aircraft manufacturing and sales. A complete monopoly. During this time frame, actually, Glenn Curtiss was forced into bankruptcy once, and then later on, in the 19-teens time frame, he was forced to bankruptcy a second time. So the Wright brothers actually forced him repeatedly into bankruptcy based off of all the litigation that they were involved in. So one of the other main conclusions, not only could the Wright brothers get an effective monopoly, or had an effective monopoly on the entire market, but it also clarified that any bypass or alternative that was being worked on at the time would not work. In other words, it may work from a technological point of actually being more efficient, effective, etc. But from a legal point of view, it would still have to go through the Wright brothers if they wanted to, in fact, use the alternative to the wing warping type mentality. So the battles, this is two different quotes here. The battles that followed drained the financial resources of both parties, meaning the Wright brothers and Glenn Curtiss. This is one reason why Orville Wright indicated that 20% could apply to everyone except Glenn Curtiss, because they were spending a lot of money defending their patent rights. Lawyers attempted to bring Curtiss and Wright together for an amicable settlement, but had no success. When Wilbur died of typhoid fever in 1912, the Wright family blamed Curtiss's stubborn refusal to back down, claiming that Wilbur had lost his health over concern for the patent litigation. Final verdict came in 1913. Orville Wright was the winner. All delays appeals have been exhausted. Federal courts have ordered Curtiss to cease making airplanes with two ailerons that operate simultaneously in opposite directions. So you ask, all right, is there any resolution to this patent war that was going on at the time? And if we look a little bit as to the flow here, 1913. So 1913 is when, at the end of the year, the judge ruled that ailerons cannot be used any further. But the patent for ailerons was released in 1913. And what was interesting is the Wright brothers, in fact, even adopted use of the ailerons as their control system within 2 years. The last Wright airplane was made in 1916, so you could see that the decline, rather than focusing a lot of their attention on technology, they were focusing their attention on really capturing the market. But again, they were so secretive up front with their own design. One, their own plane was never really manufactured that much, and two, they created such a bad taste on the mouth of all the other manufacturers that nobody really even wanted to go into this. So 1910 was the first bankruptcy for Curtiss. 1917, what was interesting is the Wright Company and the Curtiss Company were the largest airplane manufacturers in the States. So Curtiss, obviously, if he was going to go through this whole process, he was still making planes. He was still very much involved, and he knew kind of at the end of the day that he was in flagrant violation of the patent rights of the Wright brothers. So he tried everything, but he was an innovator. And so he said, you know what? Whether they have a patent or not, I'm going to continue to improve the airplane. And that was very much kind of his approach. And I think it's a testament to Glenn Curtiss's innovation in that many of the elements of the modern day aircraft are based off of Glenn Curtiss's designs and what it is they actually implemented. Everything from pontoons to actually take off and land on lakes, to different designs of the entire plane itself. Now, what really kind of ended this whole patent dispute was World War I. So the U.S. was forced into World War I, and they needed planes. They needed planes. Now, but again, even if the U.S. were going to get planes, it would all have to go through the Wright brothers, which really kind of proved to be a little bit of a hassle and a little bit of difficulty. So President Roosevelt actually pulled all these parties together, which at the end of the day was largely Curtiss and the Wright brothers, and said, okay, For purposes of the war, World War I, we are going to create a patent pool. Everybody put their patents into this pool, and then everybody will have licensing rights during the war to be able to create planes. All aircraft manufacturers were actually required to join this patent pool, and this patent pool again was just a licensing type arrangement that gave access to everyone as far as the rights of that. Now, the idea was that this patent pool would only last for the duration of the war, but the reality is the arrangement was never dissolved. So even after the war ended, this patent pool still kind of existed, and it was based off of that the Glenn Curtiss and his companies could more fully survive after the war ended. So there's a number of questions that we can ask by this whole interplay of the facts of how does the Wright brothers were using their machine, how Glenn Curtiss was innovating. So the first question for the Wright brothers is, did they invent something that was patentable, novel, and non-obvious? And I think we would all conclude yes. That this concept of wing warping, for one, was not something that had previously been done. And two, having sustained free flight off of some power source also had never been achieved. So the ability to control a sustained flight was something that never had ever occurred. In fact, that had been proved years earlier that it was not capable. So did they do something that was patentable, novel, and non-obvious? And I think we would all say absolutely. Now, what role did patents play for their company? And we may conclude it was their company, that they came up with this original design of the invention. They went ahead and they protected the invention. And then what did they do? They asserted their rights to the invention. And the invention was powered control flight, of being able to steer and change that level of incidence, or the angle of incidence of wind actually hitting the wing. Now, what effect did their actions have on competitors? Well, to a certain extent, a lot of them were stifled. A lot of them were forced out. Rather than spending their money on innovation, they were spending their money trying to defend themselves against the Wright brothers. The market industry, well, to a certain extent, it really kind of put a damper on the whole market. Rather than using patents as a means to really encourage innovation and foster collaboration between parties, patents, from the Wright brothers' point of view, was being used to effectively shut out. They wanted Glenn Curtiss gone, they wanted him out, and they were doing everything in their power to try to bring that to pass. With respect to Glenn Curtiss, did he invent something that was patentable, novel, and non-obvious? And we would say, well, these concepts at a minimum of the ailerons was not something that previously had been done. So yes, at a minimum, we would say that is something that is patentable, novel, non-obvious. Now, what's interesting is you may say, well, if he got a patent on that, shouldn't he have rights to be able to use that? And the answer is yes. But in order to use his patent, he would have to have powered, sustained flight that was capable of being controlled. In other words, his patent relied implicitly on the patent from the Wright brothers. So in order to use his patent, he still needed to have some license to the Wright brothers' patent. What role did Curtiss's actions play for the company? Well, for his company, the fact that he was continuing to innovate and create these aircrafts forced him into lawsuit after lawsuit after lawsuit. Bankrupted his companies twice. After World War I is where, again, Glenn Curtiss's companies really kind of took off. And he continued to innovate. His distaste for patents also continued even after the war for perhaps good reason. But his focus was on very much just innovating and letting the cards fall where they did with respect to patents and things of that nature. What effect did his actions have on competitors in the market industry really kind of propelled them forward. So he was trying to use patents in his technology and innovation to really open the door to other manufacturers to develop their own systems and processes as well. As far as the court and USPTO actions, first one is, was the court correct in actually granting a broad read of the Wright brothers' patent claim? And to go back now and to kind of dissect what the court did is, in our mind, we're applying our present state to trying to interpret a lot of the context of the time. But keep in mind, powered controlled flight had never been achieved. And so the patent attorney that went in to assist the Wright brothers with actually achieving that was something that never occurred. So was it right in actually interpreting it in that broad manner? We may say yes, because that is what the claims covered. On the other hand, critics on the other side may say, well, the Wright brothers only disclosed one way of actually achieving that control of the powered flight, namely this wing warping type mechanism. And so they would say, well, if you read the claim in view of the specification, it would be limited to this very narrow construction of wing warping. And so critics would contend to say, well, it should have never been constructed in the manner that the court did, but that would be a very strict reading of the patent and how it is that it could be applied. Did the Wright brothers get a patent on an idea? So this concept of being able to simply control powered flight, and again, on both sides of the argument, you may say, well, no, because they had an embodiment as to how it is that the control could be achieved, namely through this wing warping type mechanism. Critics, on the other hand, say, well, if they only disclosed one way and really didn't open the door to other ways in which it can be actually implemented, then no, they should have been required in their patent application to describe all the ways that potentially this concept of controlling the powered aircraft could be achieved. And because they didn't do so, in other words, they only disclosed one way, they should be limited to just one way. So under modern type rules, you are very much limited to what is described in the patent application. So under our modern context, we would say if this patent were filed today, the Wright brothers would likely be confined to only what is disclosed in the specification, which would likely be wing warping type mechanisms for controlled power flight. Now the ethics, some ethical questions we can ask is, was the litigation suit consistent with the meaning of the claim language? So the meaning of the claim language, again, was this wing warping. We may say, well, that was kind of a broadened argument based off of a more narrow construction of the wing warp. Should the Wright brothers be allowed to sue on something that they didn't actually come up with? And this really gets into the whole ethical debate as to what extent does the patent grant you rights. And in this case, they have rights to make, use, or sell their patented invention, which their invention was this concept of steerable powered controlled flight. So should they be allowed to sue on something which they didn't actually come up with? They didn't come up with ailerons. And so some may argue that what their patent envisioned is not what the market ended up doing. Therefore, they shouldn't have rights to that. And what we're doing is we are applying hindsight type reasoning to trying to, what you should not do with a patent application, let me be clear, is to take hindsight reasoning and actually modify the construction of the terms within the patent application. And that appears a little bit what almost went on here, where we are taking later type constructions, the ailerons, and saying, all right, well, our patent really kind of looked into the future and anticipated that things like this would actually come out. So again, that gets back to the ethical debate as to how strict of a reading should you take of the patent specification, which again, in our current context of today's market, is usually a more strict type construction.